Greetings, Your Honour. Warm greetings. It's a privilege to me to relate this message to you, and I'd like to ensure this message gets to you before the hearing, so I have contact with the court process. I'm participating with the court process. The court process is fair for me, and I can actually provide statement that's available to the counterparty and to my party and to yourself, so you can do the work that's required in your position as a judge to ensure the court proceedings go according to procedure. What I'd like to give to you and submit to the court, and would be available to the counterparty, would be my academic record from university. That should be highlighted, that my final core subject in my final year of major of my degree, I achieved a distinction. I want to forward to you a print off of my music that's been published online, that I'm quite good at that. I'd like to forward to you paperwork that declares that I'm enrolled in a science degree that's starting early next year. I'd like to forward to you at a future time, maybe not right now, but in the incoming days, statements from local and other clinical psychologists who are expert clinicians. Judge, I'd like to submit the complaint that I have I'd like to become aware of what's happening to me and the process that is going ahead that involves me, and I'd like to relate the claims leveled at me that are particularly superfluous and hyperbole in nature. Superfluous meaning unnecessary and being more than enough. Unnecessary, superfluous, and hyperbole meaning exaggerated statements or claims not meant to be taken literally. The claims leveled at me from the counterparty, because there must be at least two parties in a court hearing, is towards a nature that I possess an incurable brain disease. Now, having provided to you paperwork that can show that I'm a distinction level university student that's currently enrolled for a course, and that I am a superior musician, a claim leveled at me that's merely hyperbole and superfluous, that I have an incurable brain disease that requires, through this application that the counterparty is making, an order thereof me to be locked up from 6 to 6 months, and once we know that I've been locked in, one order's been made, one other order can always be renewed on the same basis. So to me, the way I see it, it's an open-ended order that's been opened up on me. So also the hyperbole, the exaggerated claims that not only that I have an illness, that I'm a threat to myself and other people. This is just exaggerated claims and not meant to be taken literally, because where's the police report? Where's these assault charges? There's no history of this. There's no criminal history here. So again, I'd like to put out there the superfluous hyperbole is the nature of the words, the choice of words that have been chosen to be leveled at me, these exaggerated words that I possess a bipolarity of a mental state that requires me to be locked in custody and held. That would, if the order were to go through, I wouldn't be able to complete my university course. It would be taking me out of my course. It would be taking me out of my program. It would be taking me out of learning as a very capable person that I am, learning a university degree. I'll probably be the only one learning an Australian course in Nelson, learning science, and I do desire to stay locally to teach science here. So potentially Nelson loses a future science teacher, and we do need quality teachers. I'd like to mention that it feels like a pin the tail on the donkey exercise right now to say that I have an incurable brain disease, that I have a mental disease, because I'm looking and I'm waiting, Judge. I'm waiting for the clinical knowledge, the clinical work, and the contemporary clinical practice that's supposed to be maintained. Where is the clinical knowledge? Is it just pin the tail on the donkey of putting an exaggerated claim onto me? Because I'm looking for the journal articles. I'm looking for the clinical knowledge to say that my behaviour is reversed and can be diagnosed with a brain disease. And I'm looking for the clinical knowledge. I'm waiting for it to be presented to me that I should be forced into custody and forced to take, not only forced to, that's not going to help me. There's no clinical knowledge that me being forced to custody for 6 months to 12 months and to be renewed every 6 months, there's no clinical knowledge to say that's helping me. Because I will not be able to study at university. I will not be able to become a science teacher. I will not be able to play music and play for people in public. It's not going to help the public for me to be locked up for 6 months. It's not going to help. It's not going to serve the public interest. I'm waiting for the clinical knowledge and the clinical proof in written form that I should be taking medication, because if I take medication, I'll be forced to drop out of my university program. A university student will be forced to give up their university course for a superfluous hyperbole. Superfluous hyperbole is the reason why I'll be forced to quit my university course and give up being a teacher, because to take medication and either to be forced to be at home. My home becomes a hospital room, or in a hospital room, locked up in a hospital room because of superfluous hyperbole. And I have to take medication because it's just hyperbole. It's just an exaggerated claim. I should take it. There's no clinical work that's been done. There's no clinical evidence and proof that's been shown. There's nothing. There's just an exaggerated claim. And it's speculation to say that I have a brain illness without the clinical work being available. And that I'm going to be a bipolarity in the future. Well, that's speculation on the future. How is that? How does the hearing take speculative, exaggerated claims, right? And then how does the court hearing, how do you weigh those claims? How do you weigh exaggerated claims? How do you weigh that? And how would that ascribe to the criteria of a court order being made, of an order being made? What's the criteria? Do you just weigh any claim without any clinical knowledge? And not just my clinical opinion. No, it's beyond clinical opinion. We don't want opinions. We want the actual knowledge. And the nature we can actually look at. I have two clinicians that can explain. Dr. Brett Deacon is a professor, and he can explain to you with a statement that I will have in a few days to you to explain what good clinical practice is, what's clinical knowledge, and why we rely upon good clinical judgment. Now, the hyperbole, the exaggerated claim that's not meant to be taken literally, that's what hyperbole is sort of, I can demonstrate to you that the 4 times, it's really been 3 times, but the four times that I've been to hospital for counselling, there have been no substantial events have occurred. The first time it was for counselling, and that me and my mum resolved the issue. That was 5 years ago. superfluous hyperbole, the unnecessary and exaggerated claim that's not supposed to be taken literally, that I have a bipolarity based on my history in the hospital 5 years ago when I was here. Well, there was no substantial event. It was just I came in for counselling. So I have an incurable brain disease because I got counselling 5 years ago. I have a brain disease today that can't be cured, and I have to be held in remand or in custody, however you want to put it. I have to be held because I got counselling 5 years ago, and that's the ball in the hole. That's the ace in the hole, ace in the hand. I was here in November last year. I had food poisoning. My mother can vouch for that. So is that the ace in the hole for me, for the court's criteria that I have a brain disease? Because I had food poisoning. I was here for a little over a month, and I was sick for a month. I was sick at home for a week, and me and my mum decided to get medical attention. I was back in January, a few months later in 2023. So I was here in November 2022. I was here back in January 2023 because the medication they gave me made me severely ill. And I was completely destroyed by it. Little explanation. I was provided with a little explanation why I was supposed to take the medication in the first place. No explanation. It was just thrown at me, and it made me severely ill. And I was already just recovering from the food poisoning. So the next occasion, so there's 4, I've been in the ward, and on the 4th one, is it related that if you just walk in the front door, that is proof that you have a history of a mental illness? I mean, just walking in the front door of the ward, I don't think that meets the criteria that the hearing would look at to determine if you have a brain disease or not. Just walking in the front door. I mean, I have a right to walk in the front door and receive counselling and receive services at any time for any reason. And I very much will take that up when I need to. You can't use a broad brushstroke and just say people have brain diseases from people walking in the front door. I don't think that's the work that's supposed to be done here. Now, the 4th time I was here is the one of recent times, of recent concern, that I'll read it. Late September 2023, I returned to the ward because my mum didn't know that her boyfriend, now ex-boyfriend, and myself, Ben, have a long-standing gentleman's disagreement. So when me and Mark had an exchange, my mother, Jeanette, had no understanding as to the nature of it and thought I was acting strange. She then pursued to have me assessed to see what was going on. After much discussions, my mum knows the whole truth now about the matter, and the matter is resolved, and my mother is happy to have me back home and doesn't believe I was acting irrational. So that's taken 4 weeks to find that out for my mum to get educated. So again, the 4th time, there was no substantial event leading me to be hospitalised. It was just access to services. That's it. You can establish that. Me and my mother are witnesses of this. There's not a lot of records taken when you walk into a hospital ward. There's not many records taken that are independent. There's no independent record of person went to hospital ward for services and this was their account when they walked in the front door. They tend not to write down your explanation of why you're there. They tend not to write anything down. They don't record anything. They don't do any audio recordings. There's no record. There's just my recollection and my mother as a witness as to why I was here in hospital. That's the only. They just deny to take any records. Unless you take your own personal records and your own. I have a first party statement I can make, and my mother can make somewhat of her personal first party account that we have as proof as why I walked in the front door here to receive services. There had been no substantial event. There had been no substantial episode that had taken place. An episode that cannot be explained according to normal, everyday, day-to-day family issues that are normal people experiencing them every day. There's nothing that substantial that can be linked to. I mean, there's no police report for me to coming in because of food poisoning. There's no police report that I had food poisoning, was, running around naked outside or something. I had to be apprehended. None of this is true. None of this has happened. So my question towards the court is, what is a good clinical practice that's been proven? And this is what Dr. Deakin, he's a clinical psychologist, he's a professor, that he'll provide a statement about what a good clinical practice is. And my question to put forward to the hearing to be shared between both parties and the judge to look at. And so therefore the judge, you can look at court procedures, court standards, court codes, look at legal definitions of how to run court proceedings, is a good clinical practice for me for it to be dictated upon me that I have an incurable brain disease. Like, where's the clinical knowledge there? Because I'm not finding any. It's just superfluous hyperbole, exaggerated claims that aren't supposed to be taken literally. There's no literal sense for me to say I have an incurable brain disease. Like, you realize I'm a distinction level university student who's a virtuoso guitar player. That's published online. You do realize that. You do realize I'm enrolled to a university science course that I'm studying right now for, but it's hard to when I'm locked up. You do realize that. You do realize that saying that I have a brain illness, disease, takes me out of university to just sit in a room for 6 months, 12 months. Did you understand that? And I'm not sort of talking to the judge, I'm talking to the counterparty. Like how the hyperbole, they are just floating in it. These exaggerated claims that have no literal meaning or literal sense to them. Another thing I want to look at is it good clinical practice for drugs to be dictated upon me, drugs that I have no basis to take in a clinical sense? In a clinical practice, me being forced to take drugs that you cannot describe, like, it cannot be described why. It's just a foregone conclusion. Oh, just take them. But why? You can't ask why. Well, what's describe why? We can't describe why because they can't link what the drugs do to any behavior that I've displayed. There's no link. It's just this sort of foregone conclusion that I just have to start taking drugs. Well, if this foregone conclusion is applied to society, do we just ask society? I mean, how is that serving society where we just start telling society you just got to start taking drugs now? I don't think taking drugs is a good idea. I don't take any drugs in my life. And another thing I want to look at in terms of good clinical practice is forced to live in a locked room at all times. I mean, literally, I'm in a locked room at all times. Because that clinical practice, holding me in a locked room, drugs that will cripple me, is taking me out of my university course where I'm learning a course, out of learning a program. I'm in a learning program. It's going to literally take my life apart. And for what? How is that serving society? How would an order, and this is what the counterparty, and it is a counterparty, has to prove to you, how does it serve society in applying for an order, an application for an order to the court? How does that serve society? At the end of the day, can you ask the big question with giving, with proceeding with court procedure to offer an order? How does that serve society? Because if we can't ask that question, we're really lost. We're lost in the hyperbole. We're lost in the jargon. We're lost in psychology speak, in psychology jargon. We're lost there forever because it's not serving society. Serving society is keeping people at school. Serving society is keeping people in their learning program. Serving society is not taking them from their normal life. Serving society is not forcing, without clinical evidence, diagnoses that are speculative. That's not serving society. It's not serving society to put me in a locked room for things I could possibly do, even though my life there's no substantial events in my life, psychological events. And I'm the first here in account that there's been no substantial events. And my mother, Jeanette Elizabeth Duncan, will agree there has been no substantial events in my life to lead for myself to have some type of mental disease. So there's two first-hand accounts you have. So with two first-hand accounts, is it going to serve society? With two first-hand accounts as weighted evidence, how will it serve society to just give an order when there's any application? You just give an order to it, and without even looking at it. It's not going to serve society, and that's what the court is set up to. All courts are set up to serve the public and to serve society. And I believe this. I actually believe it. I'm a true believer. And that's I think that wraps it up. I'll have this dictated.